How many thought the video was frozen? Um, okay, so it's been a while since we have had a video lecture. This is going to be over legal systems. This is the last unit of basic information that we're going to be learning before we can start getting into more applied forensic science. So we're going to get through our legal systems unit, and then we are going to get into crime scene investigation and start setting up some mock crime scenes. So let's jump in. Let's look at our main objective for this portion here. It is very important that we understand basic human rights, okay, specifically outlined in the Bill of Rights. The Bill of Rights is the first 10 amendments of the Constitution, and this is vital when it comes to collecting, analyzing, and presenting evidence. When we start talking about the legal system, there are specifically 4 amendments in those first 10 that we're going to look at that are very important when it comes to how somebody is tried for a crime and what is permissible evidence-wise and things like that. So, without further ado, let's jump in. The first one we're going to look at is the 4th Amendment, okay, the right of search and seizure. And so I'm going to read this, and obviously you're going to follow along because it's a video. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, so you will need to know that the 4th Amendment deals with the right of search and seizure. Now, what does that mean? Okay, when a court says that anyone's individual rights are violated, then the evidence that are gathered whenever, if a person's rights are violated, that evidence is now null and void. Okay, so it is very important that a police officer, a crime scene investigator, that they are following proper procedures legally when it comes to a person's privacy. We'll talk more about warrants and stuff here in just a little bit, but if those rights are violated, that evidence is null, okay? Meaning that it does not matter, and we see this in murder cases all the time, where there may be a murder weapon that was found, but it wasn't through an illegal search, and so that is not permissible in court. Okay, so it is very important that evidence is collected lawfully, without an invasion of privacy, so that it can be ruled, so that it will not be ruled inadmissible. Okay, because then it can completely swing the case. Now, there are 2 questions that are asked whenever you're discussing, is there an invasion of privacy? Okay, and if you have to have both of, if either of these questions, of these answers is no, then it is admissible. Did the owner of the home or property expect a degree of privacy? Okay, meaning that were you following procedures to the point where they knew that there was, or if they expected there to be a degree of privacy or not, and was the expectation of privacy reasonable and legitimate? Okay. Now, we probably have heard the term search warrant before. You know a little bit about that. That is an order that comes from a judge that allows a law enforcement agency to conduct a legitimate search of a location or a person to seize evidence. Okay, so there's 2 things that you really need to show to the judge to have a warrant issued. One, you need to have probable cause that an actual crime has occurred. Okay, or there needs to be evidence or contraband linked to the crime. Basically, you need to have the probable cause that there is going to be evidence or contraband there that will be found either on that person or on that property. Okay, and a judge makes that determination, and then a judge issues a warrant and allows you to go and do the search. However, there are plenty of ways to search without a search warrant. Okay, one is consent. Okay, you can be asked. A police officer could ask you, may we search your property? Okay, now if you have nothing to hide, that might be the way to go. Honestly, I would probably just call my lawyer. Not that I have anything to hide or anything. Okay, because I haven't murdered anybody in the last 3 years. So consent is given for the search, and you do not need a warrant then, and honestly, you're giving open consent that they can come and search you anytime. If there is an emergency where there is someone in danger, okay, we're talking like maybe a hostage situation, or we're talking about where there is someone on the property that is possibly wounded, you don't have to go and get a warrant to start looking for things to help you fix that situation. Okay, or maybe if there's a person who's about to flush, burn, or whatever evidence you can stop that person and seize that evidence without a warrant. Okay. After an arrest, obviously you are it's open season on you if you are arrested for a crime to be able to be searched. If something is in plain view, okay, it's like, no, I don't have a gun. Well, here's a gun, okay, sitting right next to you. Obviously you can be searched there. And if there's reasonable suspicion, you'll find this a lot as you get older and you get pulled over for speeding tickets. Don't speed, by the way. That police officers can search you on person or a car if they believe that there might be weapons or drugs. I have been searched before, at least checked over in my car as I'm wearing my the shirt. Right after high school, I worked at a Christian bookstore, and I had my Lifeway Christian bookstore shirt on, and our local police officer decided that he just might check my vehicle to make sure that I wasn't having any illegal drugs or weapons or whatever. Okay, so Fifth Amendment. Now, this is a lot of words here, but this is regulations for prosecution, for being able to actually prosecute someone and to bring them to trial. No person shall be held to answer for a capital or otherwise infamous crime unless on an indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay? They wrote things a little bit different, in the 1700s. Here's the basic thing. In a majority of states, you must have a grand jury, 16 to 24 people, who meet to decide if there's enough evidence for a case to actually go forth and for a person to be indicted for a crime, okay, meaning to be charged with a crime. And so a grand jury would meet with just the prosecution, no defense there, and they would determine, based on evidence, do we have enough to indict you? Okay, and that starts the process, okay, of you going to trial. Very important to know that. Double jeopardy has nothing to do with the game show. Basically, this is saying that you cannot be tried. So let's say I'm tried for murder, and I am found innocent. I am exonerated. However, after the trial, evidence is found that shows that definitively I'm the murderer. I cannot be tried for that again. We're going to be talking about the O.J. Simpson trial here soon, and we'll talk about how there can be some civil action taken. But double jeopardy means you cannot be tried for the same crime twice. Now, this also helps people who legitimately are innocent because, what if you just kept on trying the same person over and over again, even though the evidence didn't point that way? And this, keeps them from that. Due process just means everyone is treated the same and the process looks the same for everybody. Okay. Now, plea bargaining kind of falls underneath this amendment. When it comes to law enforcement, you try to do everything you can to gather evidence, to and then ultimately prosecutions try to sway jurors, and then it comes down to it that most cases, up to 90% of cases, are plea bargained, meaning that a deal is reached where the suspect or the defendant, I guess if you will, the defendant pleads a certain way to get a reduced sentence or to get probation, or something along those lines, because they don't necessarily want to go through the whole process and then end up getting put in life in prison. Okay, so maybe there is some sort of deal or information that is exchanged, and you get to bargain down. Okay, the Sixth Amendment starts dealing with trial policies. This one, the Sixth and the Seventh. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. I'm going to enjoy that right. By an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. To be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Okay, a couple of things here. One, speedy trial. Okay, you're not going to be put on trial, and it's going to drag out for 6 years. Okay, states have some different rules in this, but basically 3 to 4 months is how it goes, 90 to 120 days. However, you can waive your right to a speedy trial. If you want to drag it out, if you're waiting perhaps on more evidence to be analyzed or to come up, then you might waive your right to a speedy trial. There are some things that slow the process. The defendant can be out on bail. There are motions that lawyers can file that slow down the process. Illness, okay, if you're particularly sick, they're not going to put you on trial, or they're going to wait until you get a little better. And lack of attorneys. Lack of attorneys. If there's no one to actually defend you or prosecute you, then obviously that's going to slow down the process. You can actually ask for an even speedier trial, and this is a problem for law enforcement because law enforcement needs to have that evidence quick and ready to go, because if they do not and you ask for a speedier trial, then that evidence might not ever come up. And so this could actually be an issue. Witnesses, any witness for the defense or the prosecution can be subpoenaed to appear in court, okay, where you are delivered a subpoena that says you must testify in a particular case. Informed of charge. Once you are arrested, you have 3 days, 72 hours to be arraigned, which means that you are told what you are charged with, okay, and where you can offer your plea. This is something that is required. The more evidence collected before the arrest, okay, the better it is known, okay, what to charge the defendant with and the extent of the charges, and it has implications regarding the amount of the bail. Okay, so if you have, if you're collecting evidence, the more evidence you have for a more heinous crime, the more the bail price is going to go up. And everyone has the right to an attorney. If you cannot afford an attorney, the court must give you an attorney. The defense attorney gets to know everything that the prosecution has as evidence against you, okay, so that they can prepare a proper defense. And their job is to get you free, whatever it really takes within ethical and legal guidelines. And so they can question anything: collection of evidence, handling, delivery, analysis, testimony, documentation. And so it is very important that everybody is upright, okay, that everybody is doing what they're supposed to do. And finally, Seventh Amendment. In suits common law where the value in controversy shall exceed $20, yes, $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. So you are given the right to an impartial trial by jury of your peers, okay? Now, here's the problem with that. It's fantastic that you get a jury of your peers, except your peers might not know a whole lot about the legal system and might not know a whole lot about evidence. That's where in forensic science there is such a huge problem with the CSI effect, where you have a murder take place in Podunkville, Texas somewhere, and it goes to trial, and the juries want to know, what all DNA analysis and blood analysis and blah, 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 and all the stuff that they've seen on all these shows, why hasn't it taken place? And they'll actually let people free just because they weren't fully convinced, because they weren't able to actually pinpoint for sure how something went down. And so these things are very intricate, detailed, and difficult to understand, and so this can help or this can hurt, okay? U.S. courts. All courts used for trials are controlled by the U.S. government. Makes sense. And all of their verdicts are final unless you appeal to a higher court, which happens often, okay, that you are allowed to appeal. And that is actually all for this particular lecture. You need to know these 4 different amendments. You need to know the basic subheadings of what they cover and what that means. Have a lovely morning, evening, holiday.